SJC-10476, Commonwealth versus Nat Fung Ning.
No, I'm recusing yours.
Capiccio, good morning.
Good morning, Your Honors. May it please the Court. My name is Rosemary Capiccio, and I represent Yat Ing. We're here today to appeal Mr. Ing's conviction because he didn't get a fair trial. And there are several reasons that he didn't get a fair trial. I'd like to start with the focus on the issue of the excluded testimony of Omar Sierra. Omar Sierra was a friend of Mr. Ing's. He was an individual who Mr. Ing telephoned immediately after this incident, in which he told Omar Sierra, "I think I just shot someone. He was coming at me. He was coming at me." The prosecutor had indicated that he was going to call Mr. Sierra. We had indicated that we wanted Mr. Sierra to testify. In fact, I opened saying that they'd hear from Mr. Sierra. Halfway through the trial, Mr. Sierra was haved in from a correctional facility. He had a conversation with the Commonwealth. The Commonwealth came downstairs and reported then that they were not going to call Mr. Sierra. And the judge made a ruling mid-trial that the statement, "he was coming at me, he was coming at me," was self-serving, and that would not be able to get before the jury, so that if I called Mr. Sierra, the only information that he would be able to tell the jury is my client's statement that he thought he shot someone and that he had to go because they were right behind him. Now that statement, "he's coming at me, he's coming at me," my argument is that it was not entered or it was not offered for the truth of the matter asserted. It was offered to go to the state of mind of Mr. Ing as to whether or not there was a deliberately premeditated murder or whether this was self-defense or excessive force in self-defense or an involuntary manslaughter.
Unless it looks to the past, then it is offered for its truth, if it's looking to the past. So the issue is his state of mind at the time of the shooting.
Yes.
Okay, so if he indicates what happened later on, then it's a statement being made after the shooting. So it can't fall within the state of mind exception to the rule against hearsay because it looks to the past.
Except that he's fleeing from the scene. It's part and part of the same parcel. And so it's not a situation where he called him 20 minutes later, even 10 minutes later. This is a situation, and the cell phone records corroborated. As he's driving away from the scene, he's calling his friend saying, "Oh my God, I think I just shot someone. He was coming at me."
Well, maybe there's another hearsay exception, but the state of mind hearsay exception means a then existing state of mind. That's why Cardozo said in the Shepard case that it would be an end or nearly so of the rule against hearsay if the state of mind exception applied to past conduct.
Right, and this I'm saying is still under the same event. It's not past conduct. It would be past conduct, in my opinion, if it was 5 or 10 minutes later and he had time to think and reflect. But in this case, it's part of the event. It's almost akin to an excited utterance, where it's part of the entire event where he's saying, "This is what happened."
This is what happened. That looks to the past, and the state of mind exception clearly is for a then existing state of mind.
Right, but what I'm saying is if he's still under the exciting event, it becomes part of the underlying event.
I didn't understand your argument to be that this was a spontaneous utterance.
That is in the brief, that it was a spontaneous utterance as well. That if you look at what I argued to Judge Spurlock at the time of the trial, I tried to get it in under a spontaneous utterance. I tried to get it in under state of mind. I tried to get it in to disprove or to rebut the Commonwealth's burden of proving self-defense beyond a reasonable doubt. Those are the 3 ways in which we asked the trial court to consider the admissibility of this evidence. All 3 ways were requested. It was rejected, and we were left with the scenario where the only way that we could call Mr. Sierra was for him to say, "I think I just shot someone and I have to go," which didn't help our self-defense at all. This wasn't a situation where Mr. Ing was ever saying he didn't do the shooting. This is a situation where he admitted that he did the shooting, but he acted in self-defense. The entire case was him acting in self-defense. The idea that there was a statement made by him very close in time to the event, almost immediately coinciding with the event, where he was expressing what happened, in that portion of the statement was excluded from the jury. It wasn't a situation, the judge wasn't going to exclude the other parts of that statement. In other words, the judge would have let me call him to say, I did something bad, I just shot someone. Those were okay, according to the trial judge. The only part I couldn't get before the jury was the part that was exculpatory to my client, which was, he was coming at me, he was coming at me.
Yeah, you don't have a doctrine of completeness argument that you made.
Yes.
You do.
There are a number of different ways in which I was trying to get the statement in.
So one of them was the doctrine of completeness?
No, I don't think I ever argued doctrine of completeness, Judge. What I was saying at sidebar could be inferred by the doctrine of completeness, because I was saying it's not fair for you to let in the inculpatory portions and not let in the exculpatory portions. I did not mention the words doctrine of completeness, but I absolutely made that argument.
But the doctrine wouldn't kick in because that evidence was not heard by the jury.
Right, well, the reason that I didn't call, I made it very clear on the record, the reason that we didn't call Omar Sierra is because the court was excluding the exculpatory portions of his statement.
Right, but it's not as if the jury heard only part of that, of what your client said of Mr. Sierra. It didn't hear any part of what.
And that's the problem, because it was the ruling of the trial court in this case that precluded us from getting that information before the jury.
I get that. You have records with regard to that telephone call, or that's it? Are they in the
The
record?
CLSI records were introduced at trial.
And the precise time of that call, do you know?
I don't, off the top of my head, I don't know. I can certainly send a letter to tell you.
Do we know that, I'm looking for, if we have evidence as to the precise time of the shooting versus the precise time of that call?
I know we have evidence of the precise time of the shooting because there was a 911 call that went out. I know we have telephone records that reflect the calls that went back and forth.
So we can ascertain from the record precisely how much time passed.
Exactly.
Because I think one of the women immediately called 911 as
Yes.
all this was happening.
Yes.
So there's some indication that that was very close to the time of the
Well,
shooting.
it was actually the woman that Mr. Ng was assisting, was trying to help in this case. She was the first one to call 911.
Do you have other evidence that someone was approaching him? Is there an argument that this is duplicative, the stuff that you were excluded?
No, there's other evidence under, I believe, an objective standard. There's some evidence that suggested Mr. Brown was coming at Mr. Ng. Mr. Brown was the victim. He was coming at Mr. Ng, that he was charging Mr. Ng. There were a number of different statements made by independent witnesses, but nothing as to Mr. Ng's state of mind. And that was the whole issue, was his state of mind.
You do have, you get in the factual information that the victim is approaching him, but you don't.
Well, there was a dispute as to whether or not that was happening.
But there is some evidence to that effect.
There's absolutely some evidence that the victim was approaching Mr. Ng. There was also some evidence that they were saying the victim was stationary, Mr. Ng was stationary. So the evidence conflicted on that, but there certainly was at least two witnesses who claimed that the victim was still approaching and headed towards Mr. Ng before he fired.
So it's the state of mind. It's this is the only evidence you have of Mr. Nick and Mr. NG's state of mind.
That's correct. It's the only evidence that would have ever been offered for his state of mind. And that's why it was so important that it was excluded.
Did the Commonwealth ever say that they intended to elicit from him the statement that he was coming at me, he was coming at me?
In the beginning, the Commonwealth said they were calling him as a witness.
But specifically as to that?
I don't believe they specifically said they were going to elicit that statement,
Yeah.
but had they called him as a witness, then the doctrine of completeness could have come in, and I could have gotten that statement before the jury.
Okay.
Had they called him at all, I could have gotten that statement before the jury. And my claim is that it wasn't a situation where the trial court said, no, you can't call him at all. The trial court parsed out what I could and couldn't present if I chose to call him.
Mm-hmm.
And so it wasn't a situation where the trial court said, no, this is hearsay, it's not coming in. Instead, the trial court said, I'll let you have the two inculpatory portions of the statement, but you're not going to be able to get the exculpatory portion before the jury. And that was the only evidence of Mr. Ng's state of mind.
Was your claim self-defense or self-defense and self-defense of another?
Both, self-defense and defense of another. What happened in this case is that 99% of the people who walked out of the bar that night would have kept walking. Mr. Ng did not. Mr. Ng saw a woman being assaulted by a man, and he decided to get involved. And that decision affected his entire life. He wasn't there looking for any trouble. There was no trouble in the bar. He walked out of the bar after watching a Red Sox game and saw a woman being assaulted. And there were a number of other people who were just walking by. He chose to get involved. He walked over to try to help the woman who was being assaulted, and he ended up in the middle of this altercation.
But he went to his car first.
No, he didn't. No.
No, I mean, before he didn't have the gun on him.
No,
At some
so-
point in time, let me just
sorry.
slow the sequence down for a moment. So, you're saying that he leaves the bar and these two groups are having a fight, and he sees the woman who I believe might have been drunk, being harassed, and the guy's coming toward him. As I understand it, he goes to the car
No,
to get the gun.
that's not what happens. So what happens is he goes to the altercation first,
Right.
then he goes to the car.
Right, so
But
he's
while-
moving away from this.
He is moving away, and while he's
And
moving
he can
away,
just get in the car and
Mr.
leave.
Brown is coming towards him. That's the whole point. Mr. Brown's friends drag him into the car to try to get him out of there. The altercation is over at this point. Mr. Brown won't let it go. My client is walking to his car. He gets to his car. As he's approaching his car, Mr. Brown bombs out of the car, pulls off, literally rips off his T-shirt, and starts charging in the direction of my client, saying the words, "You better run." That's what he did. And when he said those words, my client reached into his car, grabbed his firearm, raised the firearm first to try to back off Mr. Brown. That did nothing to back off Mr. Brown. According to the testimony, there are two witnesses who said he kept going. It's almost like it didn't even have an effect on him.
Wasn't there some testimony about a warning shot being
Yes.
fired? Whose testimony was that?
That was one of the bystanders who said that there were two shots fired. One was a warning shot, and the second shot hit Mr. Brown.
Okay.
But the evidence in between that, Your Honor, is that he didn't change his behavior. The victim didn't change his behavior based on the warning shot. In other words, the warning shot didn't work. He was still coming at my client.
Yeah.
And that's why we're suggesting that this is, if anything, an imperfect self-defense.
That was the deadly force that the victim used to escalate the encounter, was what you're just describing? That was the deadly force?
The gun is deadly force,
I
absolutely.
don't mean the defendant's use of I'm talking about the victim.
Well, when the victim is approaching my client in this case, and the victim is telling him, "You better run," and he's ripped off his shirt, and according to witnesses, his eyes were wild, and my client files a warning shot, and that doesn't stop him, and he's still coming at my client. At that point, he's justified in using whatever force necessary. You have to understand, it's Mr. Ng, and not just the victim, but all of the victim's friends that are there. And nothing that my client is doing is backing off the victim. Nothing he's doing is backing off the victim. And that's why he fires the shot.
What about the relative sizes of these?
My client was 5 feet 5 inches tall. The victim was over 6 feet tall. My client weighed, I think, approximately 145 pounds. The victim weighed close to 200.
Okay.
So clearly, he was the undersized person. Clearly, he was the one who was trying to stop the altercation, to make Mr. Brown back off. And nothing he did caused Mr. Brown to back off.
Back off of the woman?
I'm sorry, say that again, Judge?
Victim back off of the woman?
He did get him to back off the woman. He actually went up when Mr. Brown was in the altercation with the woman. My client stepped in. He had pushed the
So
woman. My client stepped in to try to break up that altercation.
So he did break that up?
He did. Absolutely, he did.
Before he has the gun.
Before he goes and gets the gun.
You complain about you get a self-defense instruction, obviously, here.
Yes. Based on you better run.
Right. You get the self-defense. You have problems with the excessive force instruction on self-defense.
Yes.
I had trouble following what you got, what you objected to, what you didn't get. Can you walk us through very carefully that? Because you've got adjectives on various things that I couldn't figure out. Because the Commonwealth is saying the instruction was given, right?
Yes.
And was the instruction given on excessive force?
He gave an instruction that if it's excessive force in self-defense, then in that case, I believe the exact words, if I can just refer to my brief, so that I get this straight.
Right. I'm just trying to figure out what you didn't get and what you objected to. You know, so-
I objected to not getting the manslaughter instruction based on heat of passion, sudden combat,
But you
with
didn't-
no cooling off period.
But you didn't ask for those, right? You
I
didn't.
did in written instructions, I asked for them.
Then you were asked again and you declined them, right?
Yes,
So you.
but I objected to him not giving the instructions
I
as
don't-
I
but-
indicated.
But when I guess when the judge asks you, do you want them? And you say no, I take it you've given up your objection at that point, right? That's substantial risk analysis, substantial likelihood analysis.
Right, but even under a substantial likelihood of miscarriage of justice, where we're talking about jury instructions on a theory of the offense, in this case, in this case, either excessive force in self-defense or an involuntary manslaughter instruction, either way, the instructions that were given by the court in this case were not sufficient based on the case law in Massachusetts, because the judge did not contemporaneously tell the jury that to find Ng guilty of murder, the Commonwealth had to disprove excessive force beyond a reasonable doubt. That's the issue. And so if you come to the conclusion as a juror that Mr. Ng used excessive force in this case, did the Commonwealth in this case, or if the jury comes to that conclusion that he used excessive force, did the Commonwealth disprove his use of excessive force beyond a reasonable doubt? The fact that that's missing from the instruction almost required the jury, if they believe that he had a gun and the victim didn't, to find him guilty.
I'm sorry, the fact that it was missing in the instruction or the fact that it was given?
That portion of the instruction was not given, Judge. That's the portion that we're complaining
But
about.
what year was this trial?
It was 2009, I believe, Judge?
And so which version of the model instructions were in effect at the time? That's what I'm trying to figure out, because I know that we, well, it had to be the earlier version,
Yeah,
because I was involved in the second version, and I came on the court in 2009. So, so this was with the earlier version of instructions, because I know we struggled with the language that you're describing.
Yes,
And changed it.
yes.
Do we know whether what he gave was consistent with what the instructions were at that time?
I believe that this case was tried in, I think it was June of 2000 and, it was
May
May or June
thir-
of 2009.
May 30th, 2008, I think.
Okay, so this would have been the 1999 instructions, I
Correct,
believe.
yes.
Okay, and do you know whether or not whether the instruction he gave was consistent with that?
As I stand here today, Judge, I do not. I
Okay.
know that I requested an instruction similar to the new instructions, and I objected to the fact that we didn't get the instruction, so I think that issue is preserved.
Okay, because I know that there were changes in the language. And
Yes.
I know that because that language was difficult language, I believe, for a jury to understand.
And then I want,
And so what consequence, I mean, I guess since we don't know, we have to look back to see whether what he gave was in keeping with the model jury instructions or different, and then look at it. But what consequence do you say there was from that instruction not being as you had asked?
because the jury then could find that if they believe that he used excessive force, even if the Commonwealth didn't disprove excessive force beyond a reasonable doubt, they could find him guilty. I mean, that's the whole reason for that ending portion, that clause in the instructions, was that it's the Commonwealth's burden to disprove self-defense beyond a reasonable doubt.
Now, your brother says you weren't even entitled to a self-defense instruction because when he went to the car, he could have just driven away.
Well, A, the trial judge didn't find that, and B, he had an individual who outweighed him, who was charging at him, who had pulled his shirt off, and who made the statement, "You better run." He fired a warning shot. The individual did not back off, and at that point, it's my position, he was justified in using the force necessary to stop the altercation that was imminent at that point.
When you say he was running toward him, in the light most
Not
favorable...
running, he was charging, I think the testimony was.
Charging. So in the light most favorable to the defendant, is that testimony better than walking kind of fast, and they were 5 to 10 feet apart? Is that the evidence in light most favorable to the defendant?
No, there were two different statements made by two different witnesses. One is that after my client produced the gun, it was almost as if it didn't matter. He still kept going in that direction. And I think the word that he used was charging in that direction. And the second statement was that even after the gun was produced, he was still walking towards Mr. Ng very quickly.
That's what I wanted to get at. That's,
So there were two separate statements
yeah.
that both corroborated his use of deadly force in this case.
How far apart were they when he was shot?
Oh.
Well, the evidence differed. It went from anywhere between 10 feet to 25 feet,
Okay.
depending on which witnesses you believed.
And do we have, in terms of the distance between the car that the victim left and where the car was that Mr. Ng was in, do we have a sense of how far that was?
We don't have an exact measurement of that, but the testimony from the victim's best friend was that they were right there and they were trying to pull away. The evidence was that the car was parked right in front of the club and that my client's car was, I think they said 2, maybe 3 car lanes up in front of the club as well.
So we're not speaking of blocks, we're speaking of car
No,
lanes.
no, not blocks at all, Your Honor. Nothing close to blocks. I know I'm running out of time. There is one additional issue that I do want to get to, and that is the expert testimony issue. If you can indulge me just for a minute, so that I can get to that. In this case, Mr. Ng was honorably discharged from the military service. The fact that he was a military sharpshooter was completely irrelevant.
Well, you say that, but the victim was shot directly in the forehead.
Right.
If the jury may have said, well, he didn't intend to kill him, that was just a lucky shot, and the Commonwealth says, no, that was not a lucky shot. He was an expert marksman, and that was what he intended.
You can't.
Why is that not a relevant
Because
fact?
you're using a defendant's military record to suggest that he's more violent than somebody else.
No,
Not at all.
That he's more in control.
I don't think that, so his military record is being used against him. He should have had better control. This is a man who served in the military honorably discharged. The idea that they could call someone who, first of all, had no indication of what was going on, had no personal knowledge of the record that was before him, was reading a report into the record, which we had no ability to confront and cross-examine, about how it was that he was actually qualified. And then the prosecutor used those pieces of evidence to say in his closing argument, how do you know he intended to kill? Because he was a military sharpshooter. That's how you know. And so absolutely his record, his service to this country
Well,
was used against him.
whether it's his service to his country or whether it's just pure training in arms, that's the fact. It's not the fact of his service, it's the fact of the skill.
But I would say you were right if it was just the report, but when you add that to the fact that there was a photograph in full military gear with his gun introduced in front of the jury to make him look even scarier than he sat in front of that courtroom as an individual who was 5'5", not in full military gear. To me, it is just so wrong for a prosecutor to take advantage of a military record in the way that they did in this case. Either they did it because they were showing he was a sharpshooter and therefore he should have known better, or they were doing it to inflame the jury to say, of course he shot him between the eyes because he was trained to do that. Either way, the way that the evidence came in this case, the fact that they pulled a police officer who had some military training at some point in the past, who knew nothing about Mr. Ng, who didn't know about any of his characteristics, to read into the record what it was that he would have had to have done to qualify as a sharpshooter. It's a Crawford violation to start with. How do you cross-examine that record when he has no knowledge as to what happened? In understanding that they're introducing that so that the Commonwealth can make the argument at the end that they made, which is you can infer intent because he was a sharpshooter. And if you look at the actual words that the prosecutor said, he said those words. How do you know that he intended? Ladies and gentlemen, he was a sharpshooter. That's what they said. And how do you hold that against a man who served his country?
Again, I don't know that it's against his service as much as it's just a fact of education and skill.
But the
Ability.
education and skill based on what? Based on reading of a record from somebody else? It wouldn't have come in, if it wasn't a military record, how would it have come in any other way? If he was trained from a security guard to shoot a weapon, that would have never came before the jury. No one would be able to read that record before the jury about his qualifications. You'd have to find the person who actually trained him and bring them in. That's not what happened in this case. There was some aura of a military record that somehow made it okay for someone to sit in front of the jury and read it. And I'm suggesting that was erroneous, especially when you look at the closing argument that accompanied that evidence to suggest that that's how you find intent.
All right, thank you.
Thank you.
Mr. McLean.
Excuse me, Your Honor, dealing with a bit of a head cold. Good morning, may it please the court. Ian McLean on behalf of the Commonwealth. This court should affirm the defendant's convictions for murder in the first degree and illegal possession of a firearm because there was no prejudicial reversible error in this case, and it would not be in the interest of justice to reduce the jury's verdict here, where what actually happened was an execution. The defendant voluntarily entered a scrum. The scrum concluded. He exited himself from the scrum, and he said to the defendant, "So you think you're bulletproof? I've got something for you in my trunk." went back to his
When
trunk.
did he say that?
Excuse me, Your Honor?
When did he say that?
As he was leaving the initial scrum that was described, and I would point you to Record Volume 4, pages 28 and 31, where you could find
As
those.
opposed to he was being charged by the victim?
No, Your Honor, that was before the defendant had,
Well-
before the victim had moved after him.
So let's break this up. If you could tell me, not in the light most favorable to the defendant, the testimony of how the victim moved toward the defendant before he had the gun, and in the light most favorable to the defendant, how the victim moved toward the defendant after he went to the car and got the gun.
That once the defendant exited the initial scrum, his back was towards the victim, walking away from the victim. The victim followed him for at least a few steps towards his car. The defendant returned to his car.
No, but the manner, with, you know, the charging, walking fast, in the light most favorable to the defendant, what is the manner in which the victim approaches the defendant, breaking it up into how he approached before he had the gun and then after the gun? Because your argument is, well, and actually, when he goes to get the gun, the victim's actually farther away from him. So I'm asking you to tell me in the light most favorable to the defendant, the manner in which the approach was.
Your Honor, during the prior argument, you pointed to the testimony. It was walking
That's
kind
what-
of fast from Juan Tucker.
That was before.
That's once the defendant has returned to his vehicle and is obtaining the gun and is reapproaching the victim. The victim is walking kind of fast towards
That's in
him.
volume 7, right?
Correct, Your Honor. Then the testimony ranged from 10 feet was as close as he possibly got, but the recipient witnesses were all consistent that the victim had nothing in his hands.
But what, doesn't that, but he's a big guy, and he's coming at him, and he's also just beaten up a couple of other people. Doesn't he get a self-defense instruction in that context?
No, Your Honor. This is a use of deadly force self-instruction. There are 3 prerequisites.
Let's separate them out, because we got the excessive force and self-defense, but self-defense itself, doesn't he get a self-defense instruction? I mean, the guy is just beaten up a bunch of people and he's coming at him.
That's actually not accurate, Your Honor.
Go ahead, tell me, go ahead.
The victim
Again, in
him-
the light most favorable to the defendant.
The victim himself did not throw the punch. The one punch that was thrown was not thrown by the victim himself. The punch was thrown by Stanley Miranda,
Okay.
one of the other
So
people in his 3-person
So the victim
group.
has not assaulted anyone, beaten anyone, done anything?
The testimony is unclear. He entered the fray, breaking the fray up. But the one punch that there was clear testimony about came from Stanley Miranda, and that was the punch that dropped the woman that was, or the woman's boyfriend who was there.
And who dropped the girlfriend? They snatch her purse or something? Who does that?
Yes, Your Honor, that came from a shove from the victim.
So the victim shoves the woman,
Correct, Your Honor.
and he's moving towards the defendant. And
The initial fray is concluded at that point.
I understand, but he's, and so at that point, but when he comes back and follows him to the car, and he's a large guy who's just been involved in an altercation, you still don't get a self-defense instruction? I understand, I want to move, at some point I want to go to the excessive force issue and whether it was properly instructed, but it just seems like this is enough to get self-defense under our case law.
Well, Your Honor, even if it was enough for a basic self-defense instruction, it was not enough for a deadly force instruction because the defendant never availed himself of all opportunities to leave the scene. So when the defendant exited that initial scrum, what he said to the victim told you what his intentions were. He said to the victim, "So you think you're bulletproof? I've got something for you in my trunk." He went back to his car, to his trunk. He returned and re-engaged with a gun. And at that point, he said,
This is in the light most favorable to the defendant?
there's one of the witnesses testified that that's what he said as he was leaving.
I know, but you're supposed to be doing this in light most favorable to the defendant.
Well, in order to say the light was favorable to the defendant, you have to disregard that testimony that was uncontroverted.
Well, how far away was the shooting from the defendant's car?
The testimony ranges, Your Honor, that they were between 10 and 30 feet apart. Some witnesses reference car length, some witnesses reference feet.
But in terms of the defendant versus where his car was, how close was he to it was from the trunk that he grabbed the gun?
Your Honor, two witnesses said it was the trunk, one witness said it was from the driver's side door. So he opened the trunk and then opened the driver's side door, and then he returned to the fray, we'll call it, with a gun.
And how far away was he from the car when the shots were fired, or shot was fired?
No clear testimony on that, Your Honor.
Was the you better run before the defendant went to the car to get the gun or after the defendant went to the car to get the gun?
My understanding is that was contemporaneous, Your Honor. So he returns, as he's walking away, the victim is saying, you better run, and that's after he has said, you think you're bulletproof, I got something for you in my trunk, you better run, returns to his car, obtains the gun, re-engages, and then says to him, yeah, you want this, and then fired a single shot that hit him
No warning
in the
shot?
forehead. Your Honor, there was one witness that testified they thought they heard 2 shots, the other witnesses all testified 1 shot.
And in terms of the defendant leaving his car, I'm sorry, the victim leaving the car, when did that happen?
As the defendant returned to his car, opened the trunk, opened the door, what was happening simultaneous there was the victim's friends were getting him into a car to leave the scene. They got him into the car, that driver got in, started the car, began to drive the car. The victim stepped out of the car, began to walk towards the defendant. The defendant re-engaged from his car, and that's when he raised the gun and said, you want this, And then the victim said, I forget the exact phraseology, but it was like a taunt. What are you going to do with that? I forget the exact term.
So what does one take from the fact that his friends were trying to get the victim out of there, and the victim leaves the car and is confronting the Asian man in the midst of, I guess race plays, of course, a role. We've got white victims from the victim. The victim is black, I gather?
Correct, Your Honor.
And his friends are black.
Correct, Your Honor.
And then the women and the other individuals are all white.
The initial scrum, they were white, correct,
And
Your
then
Honor?
we have this one Asian defendant.
Correct, Your
Is
Honor.
there anybody else? Is he the only Asian who's in the mix here?
My understanding is Juan Tucker was of Hispanic descent, but he was just a precipient witness.
Okay, so, I'm just trying to get the timing of when the defendant goes to his car to get his gun versus when the victim leaves the car. Help me to understand what the evidence is as to that.
That's all happening simultaneously, Your Honor. There's no clear testimony that this happened, then this happened, then this happened, then this happened. This is all sort of happening simultaneously.
So when the defendant is retrieving a gun from the car, is that before or after or at the same time as the victim is leaving the car that they were trying to get him out of there?
That's all contemporaneous, happening at the same time.
And and viewed in the light most favorable to the defendant would have seen the victim get out of his car and come out towards him.
At some point, that's possible, Your Honor, but the testimony was clear that the victim was walking away from the defendant with his back turned when he walked to his car, opened his trunk, looked in his trunk, then opened the passenger side door, looked in the passenger side door, came back re-engaged with a gun, which he had previously indicated he was going to go get.
Did you say the victim walked away?
No, I'm sorry, the defendant walked away.
Oh, okay.
The defendant walked back to his car, to his trunk. I apologize, Your Honor.
The one, I know that this is difficult because it's all in a very short time frame, and the witnesses are not breaking it up shot by shot sequence. I understand that, but to the extent that you can, in the light most favorable to the defendant, when does the victim say to the defendant, you better run?
As he's leaving the scrum initially and walking back towards his car.
Okay, before he has the gun.
Before he has the gun. Correct, Your Honor. But after he had already said, so you think you're bulletproof, I've got something for you in my trunk. He turns to walk back towards his car. The victim says to him, you better run, as he's leaving. As he's going into his car to obtain his gun, the victim's friends are trying to get the victim into the car and extricate themselves from the scene. The defendant re-engages, the victim gets out of the car, re-engages, walks towards him at least to some extent. Then from a distance of somewhere between 10 and 30 feet, the victim says to him, yeah, you want this, indicating his gun. And the defendant taunts him, saying, what are you going to do with that? Do it, I believe was the phrase. At which point he raised the gun and fired a single shot and hit him dead center in the forehead.
What's the instruction on excessive force and the burden of proof on that? How is that given in this case?
Your Honor,
Excessive force in self-defense.
it's 887, volume 8, page 87 is where the instruction was given.
Yeah.
It's my understanding that the instruction was properly given from the 99 version.
So it didn't include that language about the Commonwealth must prove beyond a reasonable doubt that it wasn't excessive force. I can't remember the exact language, yeah.
If, however, the Commonwealth has failed to prove that the defendant used excessive force in rightly defending himself, then you must not return a verdict of guilty of manslaughter through the use of excessive force.
So failed to prove excessive force.
Yes, Your Honor. So it's transcript 887.
Doesn't use the word reasonable doubt, right?
No, but if you read above it, in the sentence above it, the judge is using the phrase reasonable doubt.
Just read the two sentences again, sorry.
Again, I just explained to you what self-defense is. If the Commonwealth proves beyond a reasonable doubt that the defendant used excessive force in defense of himself that caused the death of the deceased, then you should return a verdict of guilty of voluntary manslaughter. If, however, the Commonwealth has failed to prove that the defendant used excessive force in rightly defending himself, then you must not return a verdict of guilty of manslaughter through the use of excessive force in self-defense. My understanding, Your Honor, is that is the 99 instruction. And again, the instructions are not to be read in isolation, but they're to be read in their entirety. Here, there weren't any instructional errors that occurred. So, Your Honor, I'd like to turn really quickly to the expert testimony. Just there were a couple of issues in there that I wanted to address that defense counsel raised, sort of suggesting that the prejudice was implying that that this defendant was some sort of crazy sniper. That's not at all what the testimony was here. The expert that testified was a former Army Ranger. The scope was limited in nature. All that he was testifying to was to help the jury decipher Army records, which are acronym-laden and can be very difficult to
The
decipher.
defendant was stationed at different times in Boston, Fort Knox, Fort Hood, but the Detective Connolly never served in any of those locations, right?
Correct, Your Honor, but
And so what was his source of knowledge for how the instructors at these other bases conducted marksmanship training?
because the Army uses a standardized test for qualifications
But he
across
didn't
the
know
entire-
that, in fact, that he got this training, did he?
Excuse me?
He didn't know that, in fact, he got this standardized training.
He had no personal knowledge, Your
No, he
Honor.
had no personal knowledge.
He had no personal knowledge about the defendant's experience in the Army. What he did was say, here's his DD-214 form, which shows he has a qualification as a sharpshooter. This is the Army's test for what you go through in order to obtain that
And
qualification.
that was relevant, why?
Because of two reasons, Your Honor. The defendant was charged with first-degree murder. The second element is malice, intent to kill. And then he was charged with possession of an illegal firearm, which again, the third element is knowledge that it's a firearm. So the defendant's knowledge, training, experience, proficiency with firearms generally was relevant to an element of each of the two offenses.
I'm sorry, I want to go back because I want to make sure we look at the right model instructions. I just pulled up the transcript. The trial was in June of 2008.
Correct, Your Honor.
So what model instructions? Do you think the 1999
99.
model instructions?
That was my understanding, Your Honor, yes.
Okay, thank you.
So there was no prejudice here from the testimony about the Army training and experience. The witness also testified that it's a standard test that everyone in the Army qualifies with the weapon. All soldiers do this, and the Army will continuously retrain you until you reach the minimum level of proficiency. That's at volume 7, 130, 138, 139.
I haven't read the closings yet, but was there any suggestion that this shot wasn't a deliberate attempt to shoot him?
Certainly not from the prosecution, Your Honor.
I understand it was not from the prosecution. I'm just trying, when the defense closing, was there anything said about whether this was the shots in the air or, whether this was an accident or anything to that
Not
effect?
that I recall, Your Honor. I think the defense was focused on self-defense and defense of others.
But
If I'm sorry.
the Commonwealth closing said, targets come up, you cite them, you acquire them, and then you fire at them. That's exactly what he did, and that's why that testimony is significant, ladies and gentlemen. He cited, he targeted, he fired. You don't think that's prejudicial?
No, not at all, Your Honor. That's not painting him as a sniper. Every Army soldier goes through that training. It's demonstrating that this was with intent. The second element of first-degree murder is malice. This was intent to kill. This was not a mistake or something erroneous that happened. Demonstrating his proficiency, his skill with firearms goes to that second element of murder.
If I can turn you to the 33E issue, okay, you characterize this as an execution. We see cases which are executions. I understand that you're arguing that at that moment in time, and let's assume the legal sufficiency of the premeditation. Given all the circumstances of this particular individual seeking to come to the aid of a person who is a bit out of control, why is a first degree without parole an appropriate outcome here?
Your Honor, he was no longer coming to the aid of anyone at the point he extricated himself from the scrum, which the bouncer testified to had been broken up sufficiently. He was now responding to the defendant. He felt he'd been disrespected, and he told that defendant, you think you're bulletproof? I got something in my trunk for you to show you're not. He went back to his car, he obtained his weapon, he re-engaged, and then he continued. Here, I've got this for you, I got this for you. Raised his weapon and fired it from a distance of, at a minimum, 10 feet. Now, the witnesses testified differently. It could have been as far as 30 feet. shot him one time in the head. He executed the man. Here's my plan, here's what I'm going to do to you, and then he carried it out. This was not a murder too. There was no sudden passion or provocation or sudden
Some
combat.
indication that he had shown the gun first as a sort of back off?
One witness testified that he raised the gun and then brought it back down to his side and then raised it again and fired.
And then another witness said there was a second shot, a warning shot.
There were, yes, a different witness that testified that they heard 2 shots. Didn't characterize it as a warning shot, just heard they heard 2 shots. However, the majority of the recipient witnesses, I believe 7 other witnesses, said one shot.
When he shoots him, how close is he to his own car? Has he moved forward towards the victim, or is the victim only moving towards him?
It's the exact distance that he's moved away from his car towards the victim is not clear from any of the witnesses' testimony.
But is it clear that he's, and again, I gotta read the record, but is it clear that he's near his car and the victim's approaching him, or are they closing towards each other? Do we know that?
Closing towards each other, Your Honor. He goes to the trunk, and then from the trunk, he goes to the driver's side door, and then he closes the driver's side door, and now he has a gun, approaches the victim, and then they have their interaction. Testimony is not clear how far he traveled from the driver's side door towards the victim himself. So turning, Your Honors, to the state of mind issue that defense counsel argued about, today, Judge Spurlock properly excluded the defendant's statement to his Army buddy that he made after the murder occurred.
You say it was after, but how much after, do you know?
The record's unclear about that, Your Honor. The only place in the transcript where there is a time that's referenced, it was the ADA commenting on it, and he indicated it was 30 minutes. That is...
Says it was almost contemporaneous. She says the records will prove that.
Well, yes, Your Honor, defense counsel did say that. What I'm saying
Wrong?
is the only reference that's in the transcript is the ADA saying it was
But
approximately
what
30
about the cell phone
minutes.
records?
I have not reviewed them, Your Honor. I have not reviewed them, Your Honor.
So if it's contemporaneous, what then?
Even, Your Honor, it wasn't contemporaneous. That's clear, because he got in his car, drove
Oh,
away.
moments away, part of the same thing.
Not part of the same thing, Your Honor. And I would point you to volume 4, page 16, which on voir dire, the witness testified about the first thing that he said was he needed to get out of here for a bit. That shows this is not contemporaneous. He's already thinking about his exit strategy from what has already happened. That's volume 4, page 16. From there, he goes on to say, someone was coming at me, someone was coming at me. But the fact that the first thing that he said to his Army buddy, who was the person that he thought to call, in another state, was, I need to get out of here. It's not the same event. This was not an excited utterance or a spontaneous utterance, and it was not a then existing mental condition.
Is that what the voir dire was about, whether or not it was a spontaneous utterance?
No, Your Honor, the voir dire was about the content of what exactly he was going to say. In his initial interview, he had said X, Y, Z, and then apparently in a subsequent interview, once he was brought from New Jersey to the Commonwealth of Massachusetts, he said something slightly different.
So was there a request that after the voir dire that it be admitted as a spontaneous utterance, which Judge Spurlock denied?
No, Your Honor. That request was not, that's not in the record, Your Honor. The only rationale that was offered was that it was a state of mind, and it does not fit within the state of mind hearsay exception. The case that the defense relies on, Woolen, makes the same point that Qualls made a decade before that, which is it's the victim's state of mind when the defendant is aware of it, and that's the motive for the murder. It's a very limited, narrow hearsay exception, and it's simply inapplicable here. So the hearsay exception doesn't fit here. So what are the other rationales that this
I thought that the judge said on spontaneous utterance that it wasn't going to fit in there because he wasn't available.
I'm sorry, Your Honor?
But there was an unavailability response by Judge Spurlock as to spontaneous utterance and why that wasn't working.
I'm not sure that I understand how that could be because the witness was there and the witness was voir dired, so the witness was available.
I understand that. But you're just saying that that's not correct?
From my read of the record, Your Honor, the argument that it was admissible as a spontaneous utterance was not made. The argument that was made was
So that was
state of
never
mind.
made, you're saying? The spontaneous utterance argument was never argued?
That's my read of the record, Your Honor, yes. That was not an argument.
But she
that
said
was
she tried to
raised.
get it in 3 different ways, and you're saying it was only one way?
I'm saying they tried, correct, Your Honor, they tried to get in as a state of mind hearsay
That's all.
exception. Excuse me?
And that's all?
Yes. And then when that failed, they tried to say, no, it's admissible not for the truth of the matter asserted.
Okay.
And they tried to argue that it should come in on deliberate premeditation or self-defense.
Was the CSLI offered as an exhibit?
Your Honor, I'm honestly not sure about that, and I'll have to check and send a
So
16.
we don't know whether it's going to be part of our record or not.
However, the defendant was, when he was pulled over, he was brought back to the scene in that show-up identification, and a series of witnesses ID'd him during that show-up
But I'm
identification.
trying to find the time, we're trying to identify with some precision the time between the 911 call and the time of this telephone call with Mr. Sierra. Your sister says we can identify from the record based on the 911 call. Is the time of that in the record, do you know?
I honestly don't know, Your Honor, because the issue
Just have to
wasn't.
examine to see what we've got.
Yeah, I mean, obviously, even if spontaneous utterance wasn't raised, you know, we're looking at this under 33E as well.
Right, Your Honor. However, I would also point out that the defense counsel conceded that it wasn't, that it was hearsay, and then moved on to arguing they wanted to offer it not for the truth of the matter asserted.
No, I appreciate that. I'm just saying we still have to consider.
Understand, Your Honor. Understand, Your Honor.
Okay, thank you.
Thank you.
We'll take a morning break.